Sadly, the allure of criminalizing speech critical of religion, as advocated by such human rights luminaries as Pakistan, Sudan, Iran, Saudi Arabia, is beginning to take firm root at the United Nations as well. The OIC, or the Organization of the Islamic Conference, a group that dominates the UN General Assembly, has managed to pass 2 resolutions that criminalize discrimination of religion. One of those resolutions, 719, is a document that turns the concept of human rights into one of Orwellian thought control. It prohibits, quote, the dissemination of racist and xenophobic ideas. Know that its ideas are prevented here. Not only but to thoughts against Islam is what the United Nations is now attempting to ban. What's desperately lacking by those who insist on applying hate speech laws to legitimate criticism of religion is the understanding that the right to practice your religion freely does not encompass the right to practice your religion free of criticism. Secular laws must be designed to protect the free exercise of religion, not to outlaw blasphemy. And a distinction must be drawn, for example, between harassing someone on their way to pray at a mosque or standing across the street on a soapbox and insulting Judaism, Christianity, or Islam. Banning speech critical of religion is definitely a step backwards, and it is also a step towards legitimizing the violence committed in the name of Islam. Personally, I'm offended by this type of censorship, and I'm truly concerned about what the future looks like. In 5 or 10 years, am I going to be able to stand up here in this country or in Europe and give the talk that I'm giving now? And the reality is that Muslims have nothing to gain from supporting the censorship of debate about Islam. Because if a cartoon with Muhammad is hate speech now, what then is the Quran? And frankly, the actions of CARE and the CIC and others who engage in Islamist lawfare offer a very great rebuttal to those who see Islamism as compatible with democracy. Now, recognizing the severe consequences of Islamist lawfare and the need for a counteroffensive, Daniel Pipes founded the Legal Project at the Middle East Forum exactly 2 years ago. On a 3-tiered basis. First, we arrange for pro bono legal representation for victims of Islamist lawfare. Second, we financially support the court costs and litigation-related fees of those targeted. And third, we work to track instances of Islamist lawfare and raise awareness through our publications and at conferences like this. The project is currently assisting several persons who have been wrongfully targeted for their legitimate dialogue and for their public participation. We've amassed a very impressive list of an international network of attorneys who are ready to stand guard against this attack on free speech. And I encourage every lawyer in this room to join our group, and everyone who is interested in this subject to join our mailing list. Now finally, as some of you may have read in yesterday's Wall Street Journal, Senator Specter, who is one of the sponsors of the Free Speech Protection Act, which is a very important bill right now before both houses, which nullifies foreign libel judgments against American authors, he will no longer be able to address us this morning due merely to a scheduling conflict. This hasn't, however, stopped CARE from issuing a petition, which ironically calls for Specter to boycott this conference and refuses to speak publicly about the issue. As James Taranto aptly put it in his Wall Street Journal piece yesterday, running a petition to pressure an elected official not to participate in a conference on the subject of silencing free speech about Islamism would seem to prove the point of the conference. Nevertheless, we have endeavored to bring you an array of expert panelists that I know you will all enjoy tremendously, some of whom have traveled all the way from England and from Canada to be with us, to share their experiences, to share their knowledge, and we are very grateful for their participation.
Because the greatest dangers in a democracy to liberty are those that are silent and invisible. We're talking about the invisible killer of the legal system, something that can't be seen and can't be heard, because we never know when somebody is chilled from publishing something critical for fear of being sued or fear of being prosecuted. It's the very invisible nature and silent nature of the threat that makes it so important for us to expose it and deal with it. I know because on college campuses, every day where I work and Daniel works and others on this panel work, I can feel and sense the invisible nature of these constraints. You know, the good news is that on college and university campuses, there are many pro-Israel professors. The bad news is they almost never speak out. They are chilled, they are frightened. I know because when I speak at a university, the next day I always get a phone call, and it always goes like this. Thank you, Professor Dershowitz, for speaking up. It's in a whisper, almost as if the professor is afraid to be heard. And they say, we really support what you're doing, but we don't have the courage to speak out, as if professors with tenure need a great deal of courage to speak out on issues. But they are chilled, and I see it, and I sense it on university campuses every day. And if you multiply that by the thousands of instances where nobody will speak. I was talking to Charles Jacobs yesterday about the problem that occurred in Boston. And Boston has one very, very, very famous talk show host who can't be constrained by anything. His name is Carr. And he will take on anybody and anything. And on this issue, he was silenced. On this issue, because of the threat of a lawsuit against him and against his newspaper, he simply stopped writing. And when Howie Carr can be silenced, we know we have an extremely serious problem. Look, there are limits to free speech. I've devoted my life to trying to narrow those limits to free speech and expand the range of free speech, but everybody acknowledges that there are some limits. The International Court of Rwanda was correct when it imposed criminal punishments on the media there for directing terrorists to the homes of specific victims in order to kill them. That was not a proper exercise of free speech. The Nuremberg Tribunal was right when it came to the conclusion that the editors of the Der Stürmer were part and process of the genocide committed by the Nazis. I think Erwin Cutler and I are right when we seek indictments of Ahmadinejad for inciting genocide, making the distinction that Ahmadinejad is not a citizen exercising a right to dissent against government, but a government official akin to a mafia capo ordering his people to engage in acts of genocide. There are limits to free speech, but we're not today talking about the acceptable limits to free speech. We're talking, as aptly described, of guerrilla lawfare, the misuse of the law. I used that term guerrilla lawfare in 1982 in my book, The Best Defense, and I'm both glad and sad to see its application to a situation of this type. Now, this is part of a larger problem. The guerrilla part of it is a very important aspect, and we'll be hearing a lot about that today. That is the organized, conspiratorial aspect of this thing. But it's part of a larger problem. There are those who would use the law who are not Islamicists. There are those who would use the law who don't even know what's going on in this part of the guerrilla theater that we're seeing. And they seek to expand the constraints of law for their own reasons. Holocaust deniers have sought the protection of the law. David Irving, most notoriously in Great Britain, and fortunately was defeated in his quest by the great work of Deborah Lipstadt and Anthony Julius, her lawyer. I'll describe in a minute a case in which I myself am involved, where I have been indicted in Italy for a statement made in my office in Cambridge, Massachusetts, criticizing an Italian radical leftist judge who had freed 5 terrorists, calling them freedom fighters and guerrillas. And for criticizing her opinion, I am now subject to criminal charges carrying a 7-year prison term for defaming a member of the judiciary. And she, the judge who brought these charges, is not part of any conspiracy, at least as far as I know, but if she prevails, her opinion will serve as a precedent for constraining free speech. The problem, as I say, is multifaceted. And the effect, however, is very, very dangerous. Let me tell you about one effect that's extremely worrisome. And that is the combination of the guerrilla lawfare having a negative chilling effect on responsible journalists. That is, the Boston Globe, the Boston Herald, publishers refuse to publish responsible criticism because, as the Pentagon Papers case well demonstrated back many, many years ago, the reason you don't go after the New York Times and the Washington Post and try to prevent them from publishing is because we know where they live. They are responsible publishers. If they do something wrong, we can go after them. So the net effect is to stop responsible criticism, to stop responsible comments in the marketplace of ideas. But the internet permits the most irresponsible of criticism and the most unaccountable of attacks. For example, again, to get personal, just Google Dershowitz wife murder, and you will see that I murdered my wife. It has pictures, it has a toe tag, it has pictures of my children. Of course, they're just generic Jews with long noses. And it's a Holocaust denial website from Melbourne, Australia, and I can't go after them because there is a statute protecting internet websites, and you can't find the people who distribute the hate information. So the total effect is to skew the marketplace of ideas in favor of the most irresponsible being the most protected and the most responsible getting the least protection. And that has a terrible effect on the marketplace of ideas. As I say, this problem transcends politics. There are, on this platform, liberals, at least one, and conservatives, probably more than one. This transcends politics. It transcends geography. We're going to talk today here about the United States and later on about Europe. 2 points I want to make before I conclude. One is, be careful when you try to impose content-based constraints on free speech. That is, people who reflect our general worldview sometimes try to have it both ways. We want to see if we can impose restrictions on the speech of our enemies while reducing restrictions on the speech of our friends. That never works. It's always a two-edged sword. So we here today have to commit ourselves to a maximalist view of free speech, even when it hurts. And finally, we have to do everything in our power to use the law to protect those who would disseminate ideas and expressions that should be protected. Legislation, litigation, and public awareness. And I'm here to say that I want to be part of the solution to this very, very important problem that confronts democracy. Thank you.
Good morning. I've been advertised as speaking about international law. I actually want to speak about something more fundamental, our sovereignty. I tend to think of sovereignty as something we take for granted, like air. We assume it will always be there, it's always been there, it'll be there no matter what in the future. Not so. In fact, our sovereignty is rooted in our Constitution, as is, I believe, our nation's exceptional historical success. So are the freedoms that I believe have been essential to that success, to the very phenomenon of American exceptionalism. Arguably, the most important of those constitutional freedoms are freedom of speech and the separation of church and state, both enshrined, of course, in the First Amendment to our Constitution's Bill of Rights. Unfortunately, our sovereignty and these constitutional freedoms are under assault from what I think is best described as transnationalist forces. They come in two strains, the religious and the secular. Brooke has already mentioned one of the manifestations of the transnationalists of the religious strain in their effort to constrict free speech elsewhere around the world and in the United States through Sharia blasphemy laws. I would argue a similar kind of insidious campaign is underway in a fashion that is less obvious, but probably more lethal to our system, namely something they call Sharia-compliant finance. And the fact is that we now have, in both cases, the proponents of this form of religious transnationalism succeeding in insinuating these programs, again, not just overseas, but in the United States as well. For example, with the Sharia-compliant finance business, you have the Treasury Department offering courses for the policy community on Islamic Finance 101, taught by some of Professor Dershowitz's colleagues at Harvard. You have AIG, a government-owned insurance company, promoting Sharia insurance products. You have the Minnesota state government offering Sharia mortgages. This is being made possible, both the Sharia blasphemy program and the other aspects of Sharia, of course, by the secular strain of transnationalism. One that holds that the United States must be subject to international laws and rulings and even norms. Norms often defined by nothing so much as a conference held by some gaggle of transnationalists somewhere around the world, espousing a particular platform which then can in turn be said to be international normed. To put a fine point on it, we have before the United States Senate, as we speak, a nominee that is a radical adherent to this notion of secular transnationalism, Harold Koh, the recently departed dean of the Yale Law School, who President Obama would like to have be the State Department's legal advisor, a position from which he would have unprecedented opportunities to promote this form of secular transnationalism. And I think we will see much more of this sort of insinuation of Sharia programs, Sharia blasphemy laws, and other forms of international norming in our society if indeed people like Harold Koh, who's also been bandied out as a prospective Supreme Court nominee, are given positions of great trust and influence. Because all their conviction is our Constitution, our laws, our freedoms must be taken into account along with others' laws, constitutions, rulings, judgments, and so on, as though they're all just sort of equal and need to be taken as an entirety in rendering future judgments and laws. This, in other words, ladies and gentlemen, constitutes a pincer movement between the secularists on the one hand and the religious transnationalists on the other. Wielding Lawfare as politicians wielded their is in the very heart of our sovereignty and indeed our freedoms, as they seek to remake the world in their image. Of course, never mind that their image of what the world should be remade into is very different. Yes, it has a common bottom, I guess, a global world order governed by a single entity. For the secularists, it is some sort of world government. For the religious, in this case, it is a global theocracy. They will sort out their differences in due course, in much the way that the Iranian Revolution sorted out between the Democrats and the Socialists and the Islamists who would govern after the revolution in Iran. But the reality is that whichever prevails, and I think it's a fairly straightforward bet as to which would, the ruthless, the totalitarian, and the violent, it will not be good for us. It will not be good for our Constitution, it will not be good for our freedoms, and it will not be good for the rest of the free world that depends on all of the above. We must recognize such lawfare for what it is, even though at the moment it seems modest. It is a mortal threat. And only by recognizing it as such can we counteract it and defeat it as we must. Thank you.
Brooke Goldstein asked in her introduction if she will be able to give this same speech in the U.S. or Europe 5 or 10 years hence. Brooke, I don't know about Europe, or for that matter about your native Canada, but in this country the answer is certainly yes. America has an expansive and robust free speech tradition that is in no danger of being overturned. How expansive is it? Well, you often hear people say the First Amendment protects free speech, but it doesn't protect hate speech. This is probably the biggest cliche about free speech other than the one about yelling fire in a crowded theater. It's a completely false statement. The First Amendment does protect hate speech. In the United States of America, neo-Nazis have a constitutional right to hold a march through a neighborhood filled with Holocaust survivors. This is not hyperbole, this is not legal theory, this is an actual case. National Socialist Party versus Skokie, 1978. But it goes beyond this. The Supreme Court has actually extended free speech protection to speech that is worse than hate speech. In 1968, in a case called Brandenburg versus Ohio, the court unanimously overturned the conviction of a Ku Klux Klan leader who was convicted under a criminal syndicalism law. This made it a crime to advocate, quote, crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform, as well as assembling with people who propose such doctrines. Now, there's a difference between advocacy and incitement. The court said that such speech can be prohibited, quote, where such advocacy is directed at inciting or producing imminent lawless action and is likely to incite or produce such action. So if you incite violence, you can be prosecuted for that. But if you advocate violence, that's protected by the First Amendment. There's a category of speech called fighting words. These are, for example, if I go up to you and threaten you and we start a fight and you throw the first punch, I can't say, well, I was just exercising my free speech to get out of a disorderly conduct charge. So fighting words are not protected by the First Amendment. They can be criminalized. But in 1992, in a case called RAV versus St. Paul, the Supreme Court overturned a statute that made it a misdemeanor to display a symbol that arouses anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender. Sorry, there was an extra word in my notes there. So this was a symbolic hate speech law that the court overturned. The lower court had construed it to apply only to fighting words. So this symbolic speech could in fact be criminalized, but the court said you can't criminalize it on the basis of viewpoint. You can't treat fighting speech that expresses hate for a group differently from any other fighting words. And Justice Scalia wrote in that case, All right. The government, quote, has no such authority to license one side of a debate to fight freestyle while requiring the other to follow Marquis of Queensberry rules. He meant Marquess of Queensberry, but everyone makes mistakes. So, we hear about, in Europe, hate speech being used to silence things that clearly are not hate speech. But here, hate speech is fully protected. Speech that's worse than hate speech is fully protected. Alan made the point in his talk that you can't, that these are neutral principles. They apply to your foes as well as your friends. So the downside of this is it also protects the imam who preaches violent jihad as long as he doesn't cross the line into incitement. But this speech is clearly and solidly protected. Now let me say a few words about libel law, which I think our other panelists will discuss in greater depth. We hear a lot about people being sued for libel in England and other European and Commonwealth countries, but especially in England. The reason that people get sued for libel in England is because American libel law is so protective of free speech. Beginning in 1964, the Supreme Court revamped our libel law to protect free speech so that the burden of proof to prove that a defamatory statement is false is on the plaintiff rather than the defendant. In England, it's the other way around. And if you're a public figure, if the plaintiff is a public figure, which would be the case in almost every of the sort of case we're discussing here, the plaintiff then has to prove that not only that the statement is false, but that the defendant acted with actual malice, which is defined as reckless disregard for the truth. It's very difficult for a plaintiff to win a libel case in America. Now, a caveat here. Free speech does not necessarily mean speech free of hassle or free of cost. Sometimes plaintiffs file meritless cases, and it is necessary to defend them. This is why it's crucially important that anyone who's involved in commenting on an issue of public concern, especially of such controversy as this, be aware of your rights and be aware of your responsibilities, because the only thing worse than being sued, than being the defendant in a lawsuit without merit is being the defendant in a lawsuit with merit. And it's also why it's crucial that we have groups like the Legal Project of the Middle East Forum that help people who find themselves in this situation so that they can get legal advice and representation and defend their free speech rights. But the underlying rights themselves are really in no danger in this country. Thank you.